between the Maya Leaders Alliance and the Attorney General of Belize. The members of the monitoring panel are the Honorable Mr. Justice Witt, Presiding Judge.
Good morning, everybody.
The Honorable Mr. Justice Anderson.
Good morning, Council.
And the Honorable Mrs. Justice Rajnath Lee. Madam Justice Rajnath Lee. My apology.
No problem. Good morning, everyone.
Council, you may now enter your appearances.
May it please Your Honours, Nigel Hughes with Ms. Leslie Mendez and Mr. Alistair Jenkins for the appellants, the Maya Leaders Alliance.
Together with Ms. Samantha Tucker for responding.
Thank you. Mr. Hughes, you are, I wouldn't say the new kid on the block, because that would be disrespectful, but you know what I mean. I think we would like to, as we have seen the compliance reports, but I think I would like to have an opening statement from your side, Ms. Mendes or you, and then an equal short reply from the respondent, which will get us into the case. So either Mr. Hughes or Ms. Mendes.
Thank you very much, Your Honour. May I proceed? The government's report, thank you. The government's report contains several references to the multiple activities being pursued in purported compliance with the consent order. It is noteworthy that not a single aspect on which there is a notable silence is the fact that the only engagement with the appellants took place on one single occasion. Since May of last year, the parties have met only once, which was on the 17th of February 2023. Most of the appellants' correspondence has either been unanswered or ignored. Indeed, at last November's hearing, the appellants reported that the parties had not communicated or met for the preceding 8 months. Subsequent to that, the parties did not meet or communicate until after 2 months on the 17th of February, 1 week prior to the last court hearing. The appellants are of the opinion that that meeting yielded some positive results, but once again, the government did not follow through on the commitments it undertook at the meeting. The government cancelled the working session on the delimitation principles and methodology without proposing any alternative date. They also failed to provide their concerns on the DPM in writing, despite the passage of 3 years to review and consider the document. Additionally, the government failed to respond to the appellant's letter on the revised roadmap, which remains a matter of continuing importance and concern. Following Laguna's complaint to the authority about the illegal surveying activities, which were authorized by government officials, the government published a letter which significantly increased the tensions between Laguna and Urumani Grove. Members and leaders of Laguna were violently confronted by members of Urumani Grove, who, armed with machetes, entered upon Laguna's lands and demanded that the residential lot markers be removed. These members also threatened to bulldoze Laguna's lands to construct a road. In an effort to de-escalate the tensions, the appellants and the leaders of Laguna asked the government not to rush to make public statements and have the issue subject to emotive and possibly a toxic atmosphere which had developed between the respective communities. The government was encouraged to assist the parties to enter into dialogue and arrive at some mutually acceptable solution. Regrettably, that did not happen. The tensions were increased when the government declared that Laguna had acted illegally by placing markers on the land and endorsed the actions of some of the residents of the Urumani Grove. The inevitable consequence of the government's actions were a considerable increase in tensions between the communities. The resultant effect of the government's rhetoric was increased hostility towards the Mayan people and the fostering of an adverse reaction to the land rights of the Mayans. In the light of these developments, we asked the court once again, as we had done previously, to establish a dispute resolution framework and mediate the discussions between the parties, or alternatively, direct the parties to appoint an agreed mediator or facilitator. The breakdown in communication and engagement between the parties on this occasion, in fresh, more acute, delicate, and fragile circumstances, has only served to highlight the urgency for positive, responsible, and collaborative engagement between the parties. The reality is that the government has adopted a hardline approach, which, notwithstanding the decision of the court, its history and purpose, is a clear indication of their unwillingness to propose any legislation and take any action to give effect to the decision of the court. In practical terms, there's a real risk and fear that any proposed legislation, purporting to give effect to the decision of the court may be so crafted to frustrate the purpose and intent of the decision of the court to the extent that the rights, titles, and interests of the Mayan people are pronounced by the court are so diluted that the decision of the court is void in scope, purpose, and intent. The clear intent and purpose of the government disclosed by their actions and approach to the implementation of the court's decision is to disengage, refuse to consult with the appellants, and frustrate the implementation of the court's decision. Such an approach, with respect, is unhealthy and unhelpful. The appellants remain committed to the process of smooth, urgent, and faithful implementation of the decision of this honorable court.
Thank you, Mr. Hughes. Mr. Marshallek.
Yes, thank you, Your Honor. Needless to say, the government disagrees with the characterizations and the entire account just laid out. The government is not responsible for any rising tensions. What is responsible for that is the nature of the claims and the disputes that exist and are laid on the table for resolution by the government themselves. I'd like to demonstrate this with a picture right off because I don't want to take too much out. Need to see the whole thing. There. Yeah, the corner is yeah. That's the indicative map indicating the lands that are subject to claim Maya land tenure. You will notice that there are 3 little spaces within the Toledo district that are not subject to claim. And if we can highlight it, they're labeled. In the bottom, to the southwest, on the coast is Barranco. Moving a little north from that is Punta Gorda town with its 3 satellite settlements, Jacintoville, Yamago, and Eldridgeville. And if you move north, the other little green spot there is Monkey River. The tiny one is Punta Negra, and then the one up on the upper northwestern corner is Monkey River. The reality is that as awareness of the claims grow, these villages recognize that they're being boxed in, that there is really no room, nothing being left for expansion, and that has given rise to tensions. I need not explain it in my words. I can look to the extracts in the press reports produced by the appellants themselves in their compliance.
Sorry, Mr. Marshall, before you go on to that, just to be clear, on the map that is being shown, I see some areas which are in, is that yellow?
Yes.
And then some areas in what I would call, light green?
Light green. And you will see the legend in the right-hand corner, and the yellow is all that's subject to the Maya land claim.
I can't see the legend at the bottom right-hand corner very clearly, but you're saying that the yellow is the area subject to the Maya land tenure claims, is it?
Correct. And the green are non-Maya settlements in the
sorry, and the green is what?
Barranco, non-Maya settlements, existing settlements within the area.
Right. So there are about 4 pockets of greens, are there?
Yes. And you will have noticed that basically the entirety of the Toledo district is subject to claim, with the claims moving northward into the Sandpit district.
Right, and is it in respect of these 4 pockets of green that there are disputes, there are issues?
The flare-up that occurred during the period under review was between Yammer Grove and Laguna.
Yes.
That is in the bottom green, moving towards the northwest. I'll see if I can zoom in on it for you.
Yeah.
Let me zoom in. Because they're all labeled. It's just that the labeling is a little small. Come down.
Mr. Marshall, it may just be at my end, but is there any way that I can hear you more clearly? Little difficulty. Yeah, little difficulty hearing everything that you say. I know the gist of it, but that's not good enough for court hearing.
No. What I'm doing is I'm holding up the microphone in my hand now,
okay,
a little nearer to my lips. And
much better. Thank you so much.
So I see at the bottom there, I suppose, what is that? That's south. I see the Punta Gorda town.
Yes.
Cattle
Landing.
Yes.
And if you move to the left and upwards, the last dot within the green you'll see is Yammer Grove.
Yes.
And if you move to the left of Yammer Grove, you'll see Laguna.
Yes.
So the flare-up that occurred during the period was between Yammer Grove and Laguna.
Yes.
But the point I'm making is that there is this suggestion that it's the government's behavior that's leading to tensions, when really it is not. It's the recognition of these Dunmire settlements that there is really no space being left for them. And
Mr. Marshall, could I ask you what exactly that means?
Well, let me take you to what they say, because I don't want to misinterpret what they've said. I'd like to take you to the press report exhibited to the compliance report of the appellants. The first starts with a news report from Channel 7 saying tensions escalating in Toledo. And it gave a statement from Minister Balramos, and then it reported, and I quote at the foot, that the statement, and that's my interpretation, it says, it's an attempt by the state to try and create some order and restraint, especially around those Garifuna villages whose existence may actually predate that of their Maya neighbors. So what was reported in the news was an attempt by government to create some order and restraint. It wasn't about escalating anything. It was about de-escalating. Tensions are organic. They're coming up by virtue of the fact that the delimitation process is sending in surveyors and pegs into people's neighborhoods, and people are growing concerned. If we go over to the next page, report from Channel 7 again. It speaks to Yammer Grove. This is Yammer Grove, a multicultural village whose residents are Creole, Garifuna, East Indian, and Mestizo, right on the road to PG, and you will see that on the map there. So the village is over 60 years old, but the villagers say that Yammer's very existence is under active threat by the nearby village of Laguna, whose residents are claiming Yammer's land as their customary land. And if we flip over to the extract from Miss Gloria Swift, there's a lot of Garifuna was here, people from Mango Creek, Barranco, and a lot of them, East Indian also, a lot. I grew up amongst East Indian them. I just feel that they're taking chance of us. And if you flip again, now you get an extract from Miss Monica Cook, the Deputy Alcalde from Laguna Village. And if we start right at the top of that, it says, I don't think there is any confusion as to where the boundaries of our lands are. The lands that we use and occupy have always been ours since time immemorial. They are our ancestral territories, if you will, and have always belonged to our people. So whether or not there are third parties living on those lands, no, that doesn't agree to our rights over these lands. to create this narrative that we are actually the ones taking away lands from people. That is very wrong, and that is very untrue. And as a Maya person, I take umbrage to that fact. The government, the minister, she referenced auto delimitation methodology and principles. And in there, they will have to deal with third-party interests. So for her to say that there are expansions and there are encroachments going on, it's really the government that has responsibility under paragraph 4 of the consent order to ensure that third parties aren't encroaching on our lands. And if we flip again, look at Mr. Harold Usher in the middle of the next news broadcast. It says, now that we are feeling in Yamara Grove is that we have our youths, we have the need also to put a center, hurricane shelter, because the village does not have, we want to put a possible, what you would say, state-of-the-art football field. And the thing is that these people, because of the court order, they believe they have the power to demarcate and just walk into any village under the instruction of their leader. And if we flipped to the last one for Mr. Sebastian Itch, chairman of Laguna, if we go to the bottom, he says, I don't understand where the confusion is, but I guess I can say maybe it's because Yamara Grove is getting bigger. We have other young people coming up and they need space. So that is where they see the need for land. And now they're claiming for our land. We can dialogue. That is what we want. We can't dialogue. We can dialogue. And let's see how we can solve these issues. Because one side claiming and the other side counter claiming, we will never meet anywhere.
Can I just ask you? I think I get the gist. I suspect my colleagues as well. So Yemen Grove is a non-Maya village, according to the allegations which are being made.
Correct.
What about the other villages in the area painted light green? Are they similarly described?
Yes.
Okay, so all of these,
village, 41 of them are within the yellow.
Got you. Okay, okay. And you had sort of, widened it out so we could have seen some other
yes,
places.
can you try it out again? Yes, thank you.
So Mr. Marshall, if I could, just from my point of view, have your comment on this. It appears that Yamara Grove is a multicultural village, which is growing in population and needs. It would like to put things for the young people, of course. I mean, every village wants to have, proper community centers and facilities to keep the young people out of trouble and so on. So is it that in this now they see that because of the Maya villages demarcating and so on, whatever is happening on the ground, that they are seeing there? I thought I heard from you that there was no room for expansion. Is it the government's position that they should be expanding onto Mayan lands?
No, what it is that when there was this flare-up, it forced a reconsideration of the policy for determination as to whether some policy direction can be given as to how these issues should be dealt with and resolved. And the change made to the policy and resubmitted was in effect the introduction of a section that says that so long as these disputes exist, Maya custom and land title would not be registered in anybody's name unless there's agreement between the parties as to boundaries. Now, that was only a suggestion, and the reason why it hasn't been put to the other side is that it's still being thought through, and not even on the government side is it decided upon. But the point is that the flare-up intervened during the period and reinforced a reconsideration of the policy.
Would I ask you then, if we were to go further up to the, is that the northeast?
Yes.
Or northwest, maybe. Yeah. There's another
east is towards the sea.
There's another, east. There's a smaller section there, and I can't make out the name of the town because it's in very small print.
Yes, we'll try to zoom in.
Okay, but there were others as well. But
Yes, right there.
yeah,
It's Punta Negra on the bottom,
yes,
and then when you
absolutely.
move up, it's Monkey River.
So Punta Negra, that's also, according to the allegations, a non-Mayan village.
Yeah, no claims have been made to that area.
Okay, and then further up, we have a larger area.
Yes.
There, and then you're saying now going to the west, there's another large area. May I ask you, if you were to put those 4 areas together, I don't know if you've done that.
The west is the Coxcomb Wildlife Sanctuary, up in the left corner there.
I'm just trying to figure out what percentage that would represent, those 4 areas put together, as compared with the Mayan villages.
Yes, in terms of a percentage of the Toledo district, or just landmass Belize?
Yeah, well, yes. I'm just trying to do the comparison between the areas claimed by the Mayans, which are more or less undisputed. I take the point you made that there might be disputes along the margins. Yeah. But the substantive areas claimed, and as compared with the 4 areas which are alleged to be non-Mayan, I'm trying to figure out what the percentage is.
Perhaps you could use the Toledo. You could use the Toledo district.
Yes. Yeah. Yes. I haven't done those calculations. I'll have them done for you while we speak. I'll ask them to do them. I have done some calculation. I know that I can say, for instance, that the Mayas represent roughly 11-12% of the population, and the land they claim amounts to approximately 20% of the land mass of the country.
I see.
I don't know that that helps.
Well, it's not irrelevant. I'm not sure if it helps either, but yes. Yeah. Thanks. Yeah, thank you.
What percent of the population did you say, Mr. Marshall?
I get from various sources 11-12%, but I expect that it's growing as the rest. Those are the last numbers I had.
Thank you.
And it's roughly 1 million acres. And when you do it, works out to just about 20% of the land mass. But I don't want to dwell on those numbers. I only show this to demonstrate visually that the tensions that are arising can be expected. They're a natural consequence of the process, I think, in large part. But what they cannot be, you can't attribute it to what the government does or say. To the contrary, the government has sought to steady the ship, to encourage people to wait upon the process, wait upon the completion of it, and to be calm and not to take any steps one way or the other while the process is ongoing. And that has been the message. I invite your honors to look at the video recording of the press conference and the press release, the press briefing, because it's being mischaracterized in the report. So that's all I'll say on that. But I do want to make one other point by reference to another map, another visual.
Before you make that remark, Mr. Marshall, just for my own insight, what is yellow here? Is that what you call claimed by the Mayans, or is that already more or less recognized by the government to be Maya lands?
It's called the indicative map. That's basically where all indications point that the claims currently lie.
Okay, so it's not a precise, but it is more or less what is recognized. But correct. Of course, there will be disputes about particular borders and so on. But this is basically it. Okay, good.
Correct. But what I used this map was to show the pressures being created between the Maya claim and non-Maya settlements.
We understand that those kind of disputes will come up. Of course, yes, it's then how do we handle those? So, but correct. Anyway,
as a matter of policy and as a matter of mechanics. But I'll get to that. I just want to make one more point. I'll show you a second map. The map that you see shows all 41 Maya villages, and around the center of each village in bright pink is a 2-kilometer radius from the village center, which according to the evidence is the land used by the villages for residential purposes. And then around that, there's a further 8 kilometers, which according to the evidence before the High Court, is the land used for milpas. That's a farming for each village. And if you go beyond that 10-kilometer border from the center of the village, land is also used for gathering forest resources, hunting, fishing. And that third portion of land is undefined. It can spread quite wide or be quite small. But what I did here is to show you the 2-kilometer radius from each village center of 41 villages, and then added another 8 kilometers to show 10 kilometers. So that shows the area that's required for farming by each village only. You will notice it takes the same pattern as the yellow claims, except the yellow lands go even wider. But what I want to demonstrate with this visual is that you're not only dealing with pressures between the Maya land claim and non-Maya settlements, you're also dealing with a multiplicity of conflicting claims by Maya villages.
Correct.
When you look at the bottom there, you will see that the demarcation process is going to involve primarily resolving conflicting claims. It's an important point.
Yes.
I also want to make the point, this other point, is that in the 3.5 years since the DPM has been in existence and operational, only 3 villages, and their report announces the third, have been demarcated. If you do a basic extrapolation on that, it takes a year for each village to be demarcated. It means 41 villages are going to take 41 years. Now, that's basic, and that's probably not true. So even if you put it in half, 20 years, it's still way too long for us to wait to get what we need to get done here. And this brings me to my overall response to the submissions made by the appellants this morning, which is that given all of this, and given the potential for flare-ups, the position of the government is not that we delay legislation, it's that we move post-haste to the legislation before indeed somebody does get hurt. When you take that view and you recognize what's going on, the extent of the consultations, the extent of the use of mediators to try to reach agreement, the amount of time to be spent in trying to reach agreement needs to be limited, because as Your Honor has pointed out in the past, we can't let perfect be the enemy of the good. And we can't let the uncertainties and the tensions that necessarily come with them continue to flare. So the position of the government is that we must move post-haste to getting legislation enacted. And that involves a decision given the last meeting, because we did meet after February. We met only to be walked out upon on the last occasion, which was conveniently forgotten there. After a tantrum, what I describe as a tantrum, was thrown by the other side. But at that meeting, we decided that we need to press forward. We need to get the policy out. We need to get wider consultations on the policy, and we need to move to legislation. And that is our position. So we don't think there's need for any more dialogue. The appellants have made their comments on the policy. We have them, we're considering them. What they can't get on it is agreement. And I don't know that we'll ever get agreement. And I don't know that the policy will ever be perfect. The experience of other countries show that even after legislation was passed and titles issued, issues surrounding demarcation and boundaries still arise 30, 40 years after the fact. The government's position is that we have to move forward to the legislation, put something workable on the ground, and it needs to be done quickly. And those are our comments.
Okay, thank you. We will come back to some of the points that you made, but there are some particular issues that we have to look at. Just before I do that, I want to once more make it clear. I think the constitutional situation is clear. There are people in Belize who seem to think about land grabbing and that kind of stuff. There's no such thing. This is about rights, which has been established by a consent order and the judgment of this court. It is also established that the Constitution is the highest law of the land. There is no such thing as a state within the state. We have made that clear from the very start. And so anyone who would think that that is otherwise is not correct. Also, we have recognized that although there was a breakthrough in a way in jurisprudence, the consent order and the judgment of the court, it's one thing to have that breakthrough, it's yet another thing to have it implemented, to have it realized. This is very complex, which of course is also shown by the fact that we are now 8 years in trying to get this scheme implemented. This is not an easy thing. It is to be expected that there will be all kinds of issues and disputes. That's why we try to guide the parties to come up with a dispute settlement arrangement that was ultimately done. We will come back to that. That doesn't solve all the problems, but it did solve some problems. There has been progress made. The FPIC protocol has been established. Not perfect, but as I understand it from the compliance reports from both sides, up to now workable, and more needs to be done. And I do think that it is clear that consultation is a necessary thing, that without the appellants, none of this would have happened. It was their persistence in the courts that brought us to the point that was reached in 2015. And I think that we can say that these appellants should certainly be consulted. Not the only ones, clearly. So the broader consultation that the government has in mind would be unobjectionable, but we do think that the appellants have a special place in this. How we can speak about that, but this as a preliminary point. Before we get into that, of course, all kinds of things have happened, things have been said, words have impacts from both sides. Emotions have taken the priority sometimes above common sense, and that is absolutely true. But we should not focus on that. We should focus on the way forward, and we will deal with that. We have to establish the fact that last compliance hearing, we were told that parties agreed to certain dates when something should happen. Not much has come of that. That is something we can say. For all kinds of reasons, we don't have to go into all of that, but it is quite clear that the relationship that seems to have, at that point in time, improved quite a lot, is back to ground zero, and that the trust that started to grow has greatly disappeared, which is a pity. and which we deplore, if I can say so. I also have to make it clear once again, this is a monitoring sitting, a monitoring hearing. Our role is to monitor, to guide the parties towards the final, hopefully at some point, the final implementation of all that had been announced in 2015. It is nothing more than guidance. So we cannot order things in this setting. If one of the parties wants orders, then they have a liberty to apply, which cannot change the order, but it can be about the working out of the orders. But before we get to that point, I think we should try the guidance, the path of guidance. As we have done, it has been slow, but there has been progress, as I said. So I want to make that situation quite clear, because a monitoring hearing is something quite new and quite unique in our jurisdictions, and it is maybe not always understood. We can talk to you, we can try to make sense with you, but we cannot order things to do in the setting of a monitoring hearing. If more is needed, then there is always the liberty to apply, which is a limited kind of possibility, but it is a possibility. Once that is done and it is properly done, then this court can also take measures. But in this role, we cannot. We can just talk to you, listen to you, and see how far we can get. So just want to make that very clear. You have heard me saying this over and over again, but Mr. Hughes is new, so I think it's good to make that point once again. So let's come to a first point that has our interest, which is the authority. Professor Solorio, you were appointed the authority, but it has been changed now on a case-by-case basis. We assume that that is the case-by-case basis has to do with payment, not that we assume, but maybe that is wrong. We assume that the powers that you have on the basis of the earlier agreements, and I found two, which is the dispute resolution framework 2018, I think it was, signed by Ms. Monica Koch-Magnuson and Mr. Nigel Hawke, Solicitor General. That was followed up by 2020 Procedures for Dispute Resolution Authority Reporting and Dispute Resolution Framework of August 14, 2018, built on that. Professor Solorio, can you confirm that that is the situation, or is there now another document according to which you have to work?
Thank you, Justice Witt and Your Excellencies, for inviting me to this hearing. And I just want to confirm that I'm currently basically working on a case-by-case basis. I understand that my competencies remain to be the same, but I don't have a formal contract in writing. I actually haven't had that for the last 2 years. It's been very challenging to serve in this role with the dynamic with the government. At least I am still on a case-by-case basis. But I just want to confirm that there's no agreement in writing, and there hasn't really been an agreement in writing for the last 2 years. But I am still processing complaints. As a matter of fact, I did receive a complaint on the Laguna Village. And I understand from both parties that they will submit additional information on that complaint. And I do understand from the government that a cease and desist order has also been issued in the framework of that complaint.
In that particular complaint, do you have any role then to play? Because it seemed that that issue has been solved.
I understand that there's still concerns from basically the Maya leadership on the processing of these complaints. And I also understand from the state, aside from the information that they submitted to me on the cease and desist order, that they will provide additional feedback and context before I issue any sort of statement or report on that specific complaint. So I've waited somewhat to be respectful of the parties. And hopefully I do receive additional information soon so that I can issue a written statement.
Okay, and the two documents I mentioned, 2018, 2020, those are known to you?
They are known to me.
Yeah.
But again, I've been operating in this role for the last 2 years without a written contract.
Yeah.
But I am still processing complaints, and I am committed to the success of this process.
We also understand, and of course, Mr. Marshall, you can react to whatever is said, but we understand that a lot of complaints, or some complaints, are more or less directly resolved by the commissioner in first instance. And we were wondering a little bit about how we should see that. There's nothing wrong that the commissioner resolves issues, because he's on the floor, he's on the ground, and he knows the situation quite well. But I was wondering, okay, how do we have to see this? Is this kind of there is no document about how both rules have to be played, as I understand it. Professor?
I believe that the government can provide more details on the role of the commissioner in processing complaints. In my particular case, the process hasn't changed extensively. I still receive complaints directly, and then I seek additional information from the parties, and then I issue a statement based on the information that I've been receiving. But I'm not in knowledge of a specific alternative process that the government has. I actually have very little communication with the government and receive very little updates from the government side. So that's also important to understand in this forum.
Yeah, but well, the Laguna complaint, you received that in February, I think.
In March.
Or in March. Are there any other complaints that were filed with you?
At the moment, that's the only complaint.
That's the only one at the moment. Okay. Okay, Mr. Marshall, can you say something about this point?
Yes, Your Honor. I'm not aware of any document outlining it. I think what has happened is that the commissioner has been established as a central location point for communications within the government, so that he's been communicating with the various government agencies involved in whatever action is being complained about. And that's kind of the role he's taken up. And by virtue of that, in some instances, all that's required, as with Laguna, was to inform the relevant authorities that, look, this land is subject to a claim of my land tenure, and then the authorities withdrew and stopped everything they were doing. So a lot of those issues arise out of communications. So the commissioner is charged with ensuring that he liaises with all these various departments and make sure that there's compliance. And there's also training that he's involved. He offers them in that regard.
Yeah. So are you saying then that there's no overlap at all in functions between the commissioner and the authority?
There isn't really, except that the communication hasn't been flowing from the authority to the relevant government department or officer involved. It kind of flows through the office of the commissioner.
But the commissioner can make, as I gather has happened, recommendations, and those recommendations can in effect lead to the dampening down of the disputes, right?
Yes, most of his interventions have really been informing a relevant government actor that, you know, that's contravening, it can't happen in given the consent order and the state of affairs, given the claims, because it seems that some of these decisions are taken without a full appreciation of the meaning and effect of those obligations.
But in one case, the dispute between the Emery Grove and Laguna communities, I gather the commissioner generated a report. Did he not?
No,
No?
not the commissioner. I think you're talking about Mr. Carl's report, which is exhibited to the compliance reports. He's from the Ministry of Natural Resources. He's not attached to the commissioner's office. That's the Ministry of Lands sent somebody in to make sure that the activities that were giving rise to the problems weren't being done by the government itself.
Okay, and so is that the report in respect of which there is a dispute as to whether it was widely shared?
Well, apparently, yes. The short answer is yes. It's exhibited to the affidavit that was filed by Ms. Santos setting out what. So it was shared, and there's really nothing in it that we don't know already, which is that both villages say the land is theirs. Some survey markers were put down on the authority of the village council and alcalde from Laguna, and that's what gave rise to the issues. The precise location of them were identified. They are, in fact, if you look at the map, right in between Emery Grove and Laguna, which is not surprising. Again, there is nothing at all remarkable about what was found there. What it did confirm was that the markers, the surveys that were being done, that were giving rise to the issues, were not being done by the government.
Okay, thanks.
That still doesn't resolve the question exactly what the relationship is between the task of the commissioner in resolving disputes. And once more, it's good that he does that. But I think I saw some remarks from government side where the village was kind of blamed that they filed a complaint with the authority while they could have gone to the commissioner first. Now I might be mistaken, but I think I saw something like that.
I think Council is trying to get your attention, Chair. Council Mendez.
Yes. Yes, Ms. Mendez.
Yes, thank you, Your Honors. Perhaps I can just comment on the relationship as we see it between the commissioner and the authority.
Sure.
I think in our view, there's no real overlap. At least what we have received or what we have understood is the role of the commissioner is as has been explained by Mr. Marshall, which is that he liaises among the government departments wherever some complaint or he learns of an issue with respect to generally any issue pertaining to indigenous people in Belize, yes. Right? Now, as that is his role, I could imagine that there would be some cases where some communities would be able or would feel that they would go and report to him any issue that arises. And if it is resolved, the issue ends there. However, I think with respect to the authority specifically and paragraph 4, which really determines what the scope of the authority is that communities are free to also, or to in fact not go to the commissioner, but go, it is upon their election to go and file a complaint with the authority, depending on whatever circumstances and whatever the community elects to do. So I don't see an overlap. I also don't know that the commissioner himself has any specific powers. And so I don't think that there's an overlap. At the end, the commissioner represents the government, and the role of the authority really was to act as an independent, impartial mechanism that could come in and mediate and offer recommendations as well based on her expertise.
Yes. So, but there is no problem with the commissioner solving practical problems, even as a representative of the government, as long as as long as the disputes are being resolved, that's fine. But if there is a real problem which cannot be dealt with at that level, surely I think that is clear that it is the villages are free or individual Mayas are free to file any complaint with the authority. Is that also your understanding, Mr. Marshallek?
Yes, Your Honor, that's correct. In the case of Laguna, where the complaint was made, it's just that it was perceived as a fairly straightforward matter, where once it was brought to the attention of the people involved, it would have been stopped.
Yes.
So the commissioner felt he could deal with that.
Okay, good. Well, then that is clear then. Now that we are at Laguna Village, we have to get into that conflict they have with Jeremy Groove. That is a border dispute, as you said. I think I saw that the ministry was preparing a letter, which I suppose will give a proposal to solve the problem. Because if there is a dispute like this between a Maya village and a non-Maya village, there needs to be a procedure to resolve it. Is that correct? Mr. Marshall?
Yes, there is one, and I've seen an agreement drafted setting out terms of reference as to how that's to be resolved. In looking at it, though, our concern, or my concern, was that it doesn't involve all the possible parties to the dispute. If you look at the map, it's not only Laguna that would have claims among Yamaruns now. It's also about 4 other Maya villages that would have claims upon the very same area, so that it would have to be spread wider to include those as well if a final resolution of those boundaries is to happen. I can bring up the map and just show you, but you will see that there are villages all around Yamarugu, any one of which the 10 kilometers expands and covers the entirety of Yamarugu. So
yeah,
that dispute, anyway, I'm afraid, is a little bit complex.
I take, of course, it's complex. I take that point, but the point is it needs to be resolved, however complex it is. And the way to do it is not with trespassing or going to another village with machetes. I think we can agree on that.
Oh, yeah.
It has to be resolved peacefully and according to certain. Can I assume that the delimitation principles are then being applied in whatever proposal for a resolution?
Well, here we go. Those were under review, and this has highlighted some of the limitations of what has been put in that document, in that requires agreement between the parties to resolve it. And the obvious question is what happens when the parties can't agree to the boundaries, and which body or authority then must adjudicate upon that issue. But we thought about that and whether or not it would be appropriate to establish a body to adjudicate upon, to perform some sort of adjudicatory function here if agreement can't be reached. But then there's the overarching problem as in accordance with what principle does the authority decide the disputes, so that we come right back to the need to settling the terms of the entire legislation. Sure. And that's why we came to the conclusion that moving to the legislation is, or as a matter of urgency, is what is required in the circumstances. But yes, in the meantime, the agreements for trying to come to agreement will be pursued.
Yes. What I didn't understand was that apparently after the incident with the machetes and so on, the police was called and that they would have said, well, we can't do anything. Not even send these people with the machetes back to their village. That surprised me. That surprised me. I think it a function of the government who has the power of the sword, as we call it, to stop any things like this.
Of violence, of course, and that's why we say that recount of what transpired has been mischaracterized, because the police would have stood by and allowed violence. What the police was really saying is, I can't resolve whose space it is.
No, that's true. That is true, but they could have said, and maybe they said, I don't know, but they could have said, listen, you can't solve
No
this
machetes.
problem with machetes, so go to your village and
Right.
keep the peace.
Right, and that was what the minister came forth and said, and asked people to go back and hold calm. And that's exactly the approach that was taken, because the people with machetes did retreat. There was no machetes wielded at anybody. But it did demonstrate, bringing it along did demonstrate the urgency of having a mechanism for dealing with these types of things.
Yeah. Ms. Mendes.
Yes, Your Honors, thank you. I don't want to go back and forth on how we characterize whatever happened. This is actually a constant complaint that communities have, and we have raised it with the commissioner, we have raised it with the CEO, we have raised it repeatedly, that the police department here, and I believe even before this court, we had an incident in Indian Creek as well, where the police department does not have or represents to us that they do not have clear instructions or a mandate to do anything on communal land, including coming in and dealing with some issues that present threats to life and safety. And so I don't see that at this point, at least without a proper investigation as to what happened, we can say that that is a mischaracterization of what happened on the ground. These are at the very least here allegations that deserve to be investigated. And I can say, at least from my role in these proceedings, that this is not the first time that we have heard that police officers here represent to communities that in fact those are their instructions. And I think that that's worthy of looking into, as opposed to simply dismissing it as a mischaracterization.
You would agree, of course, that the police cannot solve the land issue. That's clear. But if there is any disturbance of the peace, whether by threats or possible threats or violence or whatever, destruction of properties, they can act. They can always act.
Absolutely, Your Honors, and the police has not been called on to try to determine any issue with respect to boundary and rights over those lands. In fact, what we have been trying to get the government to commit to is the DPM that we hear again that is under review. But even if it's under review, we should be guided by it. And so with respect to that, there are very clear procedures there when it comes to dealing with disputes between communities. Yes, I agree. This has been absolutely foreseen. In fact, on the ones that we have supported, we have produced 14 agreements between disputing communities that have now agreed where their boundaries are. So there is a clear process that is involved on how we support communities that have disputes over their boundaries. This is complex, but this has been foreseen, and there's already some work that has happened. If we can improve it, let's improve it, but let's not act as if that has not happened. Again, we have 14 boundary agreement that we have concluded among communities, and this is what we're using, and this is what we suggested to the government with respect to Emery Grove and Laguna.
Yeah, well, I wanted to move away from the specific incident, which I think we can all agree on perhaps was not handled in the best way possible, to the more default and general position that I think Mr. Marshlek was advancing. As I understood him, he was saying, he was agreeing with you, Council, that where there is agreement possible, there should be agreement, and it is commendable. There have been so many agreements, as you have mentioned. Where, however, there is no agreement, I thought he was suggesting that the mechanism being proposed in the legislation was not to award the rights in respect of either side, to leave that to be determined by another process possibly, but that we should not allow that to hold up the process of the enactment of a legislation for the, I think, quite persuasive reasons that he gave. How do you feel about that?
Your Honors, we have been discussing and attempting to advance discussions on legislation as to how we can start drafting that legislation parallel to what is happening on the ground with respect to delimitation. The DPM, Your Honors, also provides for a mechanism where the parties cannot agree. And in fact, it says that a panel should be established with the agreement of the community of the villages, where they participated the establishment of this panel. So again, there is already something provided for the event that communities might not agree, because I don't think that that was absolutely unforeseen. We could very easily imagine communities not agreeing. So at the same time, though, I think if there's already something that is being considered to improve that process, then I think that we have been awaiting clarity on what those suggestions and those issues are.
Yes, I just
we are ready to engage in the discussion with respect to the legislation, Your Honors.
Not to interrupt you, but what I understand Mr. Marshall to be saying, and correct me please, Mr. Marshall, if I'm wrong, is that you want to cauterize those situations where there is no agreement and be able to move forward with the legislation. Now, I understand you to be saying that there's already a procedure in place where a panel can be constituted and so on. There could be obviously ancillary issues about how you constitute the panel and so on and so forth. So the question I'm asking you is, would you agree to a process whereby the legislation goes forward? Most of these issues have been resolved, but in one or two cases, they're still outstanding. We cauterize those issues and do not allow them to impede the progress of the legislation, because I'm sure you'd agree, as I gather Mr. Marshall does, that getting the legislation forward is very crucial. So that's the question I'm really raising with you.
Crave your indulgence, Your Honor. Your Honors, I think that is something that we would require a bit more time to fully consider what would be our position with respect to that. But in terms of talking and developing the legislation, we have no issues with having that process run parallel to the demarcation of the boundaries, whether it's completed or not. Once we are properly consulted, I think that we have no problem with that process running parallel to it.
Yeah, thank you. Thank you, Chair.
And of course, it is clear that it is about consultation. Of course, it's still the responsibility of the government to propose the legislation and for Parliament to adopt it, of course. You would agree with that, Ms. Mendes?
Could you kindly repeat, Your Honor?
Well, I said that it is, of course, your wish and probably right to be consulted in the process, but it is not, you're not a co-legislator. It is the government who has to make the proposals for the legislation and Parliament to adopt them. That is how it is in a properly constituted state. Would you agree?
If I may try to help you, Counsel, I'm sure you'll take into account the fact, as the chairman said earlier, that there is a liberty to apply provision in the order. So if having gone through the process, the government does something which you think is inconsistent with the order, then obviously you have the liberty to apply, and the court will adjudicate on whether the court considers that what the government has done complies with the order. It does not seem a reasonable way to proceed.
Your Honors, my understanding, however, just to add to what Your Honor just mentioned, yes, we accept that obviously it is the government that passes laws, but there had already been an agreement between the parties about the role that the appellants would have in working together with the government in developing those laws. And so there is a concern about going back on what had been agreed upon with respect to what this process would look like, because we can also appreciate that this is a unique process and this is a unique order that was agreed upon, in fact, in a settlement. So there are some expectations with respect to the appellants as to why they entered into that historic settlement that we constantly recognize, and the nature of these proceedings before the court. So that when we speak about consultation, the concern here is that this is not ordinary consultation. So that simply us sending in our comments within a particular period of time, I don't think would really meet the spirit and the challenge of the consent order and why we have been before the court for 8 years now. So that really is the concern here, and this is an ongoing concern that we have brought to the court. But at no point in time do we say that the appellants can pass laws, but the role of the appellants in developing this particular law, I think, is a special one and should be recognized as such.
I suspect, unless he were to contradict me, which of course he's probably going to do, that Mr. Marshall would accept that the appellants have a role, indeed a special role, given the history of the litigation, in making proposals, and as you say, in the consultation process. I gather he's saying, though, that as far as the government is concerned, they have received the proposals, recommendations that you wish to make. I assume that he's still open for the recommendations. But at the end of the day, as the chair said, the government will pass the legislation. It may be unwise for them to do so if they are aware that you have very strongly held views, such that those views would be expressed in subsequent litigation if you are not happy with what is passed. And I'm pretty sure that given the experience of counsel, that would be part of what he would be looking at and advising the government. But as you yourself have said, Ms. Mendez, 8 years have gone. We don't want 10 years to come and this thing isn't finished. Really, we can't. So can we see how best we can move forward with the passage of the legislation, with the government taking into account what you have said, and bearing in mind your complete autonomy to apply to this court, full court, to seek a review of what they have passed, if you think that what they have passed does not pass muster.
Ms. Mendez?
Your Honors, I take, and I might be mistaken, but perhaps a clarification on this point here, that Mr. Marshall-elect's representations to the court today and the proposed way forward is that we will be participating in this process through written communications alone, and they will take into account what we say, but there won't necessarily be a dialogue or a meeting with the appellants with respect to how we iron these things out, and there is also no longer a very clear endpoint of appreciating that this most desired goal is for us to agree on the content of the legislation. We would take issue with that approach, Your Honors. We don't consider that really reflects what the consent order envisioned. And with respect to the content of the legislation, it's not only on certain points, Your Honors. Our concern is that it's not only unwise, but in fact, at least what is being proposed in the policy, for instance, breaches the order because it does not recognize the substantive rights sought to be protected and recognized under the consent order. So that would be our position. Perhaps Mr. Marshall can provide some clarity with respect to what really is what we see in the future with respect to the interaction between the parties.
Yes, well, what we have expressed is there needs to be consultation that is clear from the order. It needs to be proper consultation within the context of indigenous rights. Whether it's proper or not, that is not now for us to judge, of course. We do say tentatively that we do think that there is a special role for the appellants in this consultation process. That doesn't need to mean that others could not be consulted. Of course, the order says the Mayan PPI and more litigation. I think our role as giving guidance is just to make it clear also to Mr. Marshalik that the government should take this in consideration, that, you know, we do not want this to deteriorate into further litigation, but there is a possibility that it will. So I think if everybody does a little water by the wine, then we should be able to go further on a healthy basis. There is this proposal, and I will ask Mr. Marshall to react if you wish, but there is this proposal for us to appoint, as it were, to direct that a facilitator is going to be appointed and an international expert. But in his letter, Mr. Marshall already made it clear that the government doesn't want that. And so these are things we cannot, certainly not in this procedure of monitoring, we cannot push that through anyone's throat, so to speak. However, it is clear that maybe a more tight supervision of this court is necessary. I don't hope so. But we all are here for the same goal, that whatever has been expressed, the rights that has been expressed and consented to by the government under the Constitution of Belize, that those will be implemented. There will be no perfection. It's impossible to be perfect in this area, but it should be good. It should be good enough. And that requires also consultation, proper consultation, in the context of this particular case. Now, yes?
Oh, sorry to interrupt you, Chair. No, but I thought that Ms. Mendez had raised a very specific issue about the engagement of the appellants in the process going forward. And I thought that Mr. Marshall was just about to respond to the specific issue.
Yeah, and I want him to react to that.
Yes.
But I just want to make it clear that, you know, if not sufficient consideration is given to this idea, then we might end up in further litigation, and we do not want that because it will hold up even further.
Chair, can I just say, I see that Mr. Hughes as well has had his hand up for a while. And Chair, you made the important point about proper consultation. May I add the word meaningful consultation, which is what I think Ms. Mendez has in mind. Thank you, Chair.
Yes. Okay, let me then first ask Mr. Hughes to say what he needs to say, and then I will come back to Mr. Marshall to see if he can, if he takes the point, and maybe that may give him a different perspective on advising the government. Mr. Hughes.
Thank you so much, Your Honor. I just wanted to indicate that, of course, there are several stages before the legislation becomes enacted, before it is presented as a bill. And I'm sure that there are more than ample opportunities before it is actually laid in the House as a bill for final consultations, because I believe insofar as the rights of the Mayans are concerned, it would perhaps be useful to have, particularly at that point before it gets to the bill stage, to have the participation of the appellants in that process. It would perhaps stave off a lot of unnecessary litigation down the line. So I was just seeking to remind that the process before it actually gets to legislation does afford the government several opportunities for them to actually consult and allow the applicants to participate.
Yes, thank you. Mr. Marshall.
Yes, Your Honor. I must confess that I'm receiving a bit of mixed messages because I sat and listened to Ms. Kopp when she read her speech prior to walking out the meeting. And it was very clear that she was telling us she does not trust us and she has no interest in continuing to meet with us. And it was immediately after that speech that we convened among ourselves and decided on a way forward, which was to nonetheless put the policy out for wider consultations, including to them, and if they wanted to say something else, they're free to do so. And that was with a view to completing and undertaking meaningful consultations, because we have consulted already, we have written comments from them, but the door is not closed. But in the context of them telling us in no uncertain terms that there is no trust and no desire for this to continue, and walking through the door, they come here now and tell us they want to meet again, but with some facilitator.
Yeah, but, Mr. Marshall, sir, as you know, people are entitled to change their minds,
Yes,
so,
they are.
we have a different situation now. So let's not go back too much into the past. I mean, she's asking about the procedure going forward.
So I appreciate that. That's what I'm saying. So that now there is being put on the table meeting in a certain context with a facilitator. We think that that will only slow the process down. It has already reached a certain stage, and we really wanted to push it forward to see some legislation drafted, rather than looping back into these discussions that seem to lead nowhere.
So I gather then that in going forward, you are prepared to consider not just the written submissions, but to have a meeting with the appellants, the representatives, in the course of drafting the legislation. As Mr. Hughes pointed out, there are different stages. Did you have a particular stage in mind where you think that that kind of intervention would be useful?
Your Honor, where we are is that the policy was again being revised, and the revised policy goes again to a cabinet subcommittee for the approval of the revisions, and then they go out again for everybody to say whatever they want to say about it. And it's only after that's settled and finally approved that we hand it off to the drafters as their instructions as the basis for starting the drafting process. So we weren't even at starting the drafting process. What I'm trying to push through is the instructions to start the drafting process.
But sir, not to interrupt you,
layers
sir.
of consultation.
Senior, not to interrupt you, but wouldn't it be better to have their involvement before it goes to drafting instructions?
Yes, they have done a first pass, so have we. We've changed it, and we'll put it back again for a second pass so they can say what they want about the changes. And then we'll go to the wider public as well. So they have a say. So the people of Yammer Grove and other villages like them get to see it as well and get to say whatever they have to say. And then it goes to the drafters. So we think that's a reasonable approach. And we see no reason to loop back into private discussions with a mediator to come back right again for the third time to the impasses that exist.
Mr. Marshall, I must admit that, of course, the statement made by the representative of the appellants, which was followed by walking away from the meeting, was quite emotional. But I must also say that I think your letter of the 5th of May, well, we cannot deny a certain robustness of some of the remarks you made. So and we understand all of that. This is not an easy thing. Emotions play a role; they flare up and all of that. but I think sound minds have to prevail, and I think you can fulfill that role. I also understand that the government has to take into account not just this project, but also the feelings and emotions of non-Maya people and all what comes with that. We understand all of that, but I think we are trying to make clear that a little flexibility also from the government side is necessary. We understand all the emotions, but I think even if that has to lead to a short delay of 1 or 2 months, but you would be able to get things through. We were going to have something in June. That is postponed to August. Well, if that is September, okay. But we need to get some good, a proper consultation. And we think at this point in time, we think that it would be helpful if the appellants get a more prominent role in that. Of course, there should be no emotions further delaying this. It should be done in a business-like way. I think, well, now that Mr. Hughes, who is at a more distant from the case, came in, that might be helpful in getting things back on the rails.
So
I see.
In practical terms, then, given what, and please, I hope we're not going to go back to what was said and who said what and who walked out and so on. The point is, if, as the chair said, we all recognize that the appellants have a special role in the consultation process, the question is whether some space can be carved out between now and I think it's August that then you did, yes, where there is a meeting with the appellants to once again discuss the issues of concern. We accept, of course, that the government in the end will make the final decision.
Sure.
Right? But given all that has been said about the place that the appellants occupy in this process, can we agree that we make another attempt to have a meeting with the appellants? And if
Yes,
so,
we
can we sort of look at a time period within which that can take place?
Yes, we can, Your Honor, and I take your message I understand it very clearly, and yes, we can make another effort. I think the amended policy goes to the cabinet subcommittee. We were hoping in the next week, and then after that week, we can meet with the appellants and show them even the proposed revisions that have already been crafted, and we can consult again and get their input on it. There is no problem with that.
Can we tie down some dates for that, Mr. Marshall?
I think
you said, yeah.
Your Honor, could I?
Yeah. Yes, Mr. Hughes.
I was just wondering in the process there, quite often decisions that come out of cabinet have a certain finality about them. So I was wondering whether the benefit of an input from the appellants going to cabinet for consideration rather than after cabinet had deliberated, because I think positions tend to get a little solidified, especially at the cabinet level, and maybe depending on the context be perceived as a challenge, rather than if before they get to cabinet they have the benefit of the position, and then there can always be consultation after that. But at least there will be more information going to cabinet in terms of context, the order, etc., so that during their deliberations they can have a sense of all the potential positions on the proposed legislation. It was just an offer.
I think Mr. Marshall is eager to respond.
That's appreciated, and I think we canvassed that the last time, and so we've been very careful in that what is being sought is cabinet approval of a working draft for the purposes of consultation. So it is in its preliminary stage. it's not the policy itself, and we were at pains to explain that in order to facilitate it going out, because we think there probably will be changes after people have had a chance to look at it and talk about it. And we just want the first step taken. And we've been very clear about that to Cabinet. So it's the approval of a working draft for the purposes of public consultations.
So would you say the week of the 19th of June then might be a feasible time frame? Or you want more time?
Your Honor, the CEO is telling me she's not here that week. Can we propose a date? We've just, because it is a working group, and I can't speak for everybody just now. But we can undertake to do it before August. Before August.
Yes. I don't know whether the appellants would want to suggest a date so we can lock that in here and now.
Ms. Mendes?
I'm sorry, Your Honor, I missed that.
So there will be a meeting, at least Mr. Marshall agrees with that. And he says at least before August, but maybe you have a more concrete date in mind. And end of June would be difficult, but maybe somewhere in July.
Your Honors, I think a date before August is fine, provided that we are getting a response to our letter and our concerns that were raised in with respect to the policy. I think we're still awaiting a response. There were some questions, in fact, that we posed to the other side with respect to clarifying some of the terms that are being used. There are aspects of the policy that are quite vague. So I think that if we can also work on a written response from the government to that letter, and then we work out a date before August to actually sit down and meet. I was raising my hand as well, Your Honors, because I simply wanted to try to address the issue with respect to the facilitator. I know Mr. Marshallek raised that there would be a concern about whether this would delay the process much more. But the experience in the past has not really shown that. When there was a facilitator that was invited to assist the parties, that was actually what produced the December 2018 agreement as well as the DPM. So I make that point just to address the concern, and perhaps the government can again reconsider its response with respect to our suggestion to have a facilitator.
Yeah, well,
yes.
Yeah. Yes, Justice Anderson?
Yeah, well, first of all, maybe we could hear from Mr. Marshallek. So there are 3 items now on the table. One is a written response, first of all, before we have the meeting. And then I don't think Ms. Mendez was in a position to give us a date possible for the meeting. And then thirdly, the issue of the facilitator.
Mr. Marshallek?
Yes, sorry. I was trying to get the 3. I was multitasking here. On the last first, we don't think a facilitator would help. The 2 documents presented as successes for facilitator, we don't view as successes at all. Both of them have required substantial revisits. I think it's important to get the buy-in from the working group and the cabinet subcommittee before we take it to the other side or to their experts, because otherwise we just keep looping back into starting over. And that's been our experience. We've gotten this far already, and we've had a series of at least 5 or 6 iterations of the policy and the meetings with the working committee. And this is the draft for the purposes of consultation. And it keeps changing. And the reason why there isn't a response to Ms. Mendez's letter is because the draft has already moved on from where it was then, taking into account certain things that transpired in the interim. we want to get the consultation process going in earnest, but as I've indicated before, it's important we do so from a position where the government itself is in agreement as to all the terms. And while that might not appear to be a challenge, it has been a challenge.
Ms. Mendez, given what has been said, we are back to the issue of trying to identify a space where the two parties can meet together to discuss matters of concern. Would you be willing to forego the receipt of a written response to your queries, given the explanation that the draft has moved away from the draft in respect of which you sought those answers, and simply go to the meeting, review the document that has been put forward or that will be put forward, and then, if you wish, make any written interrogatories of that document as we move forward? Is that a compromise that you're willing to consider?
Before you answer that, Mr. Marshallek, well, there is a revised draft at the moment that has to go to cabinet.
Yes.
Would you be able to submit that new document, let's say, at least 1 week before the meeting?
Yes, no, certainly. They need a...
Yeah, so that would then be a kind of response. Maybe not full, but at least some.
Yes, yes.
Yes. And the changes were provoked in large measure by the flare-up.
Yes.
A recognition that there needs to be closer attention to that and how to deal with it.
Okay, so Ms.
Ms.
Mendez.
Yeah, do we have an indication by when we can get that revised version? I think that serves as a sort of response in and of itself, right? But we would want that as soon as so that we can also properly consider it and prepare a response, and as well going into the meeting.
Mr. Marshall.
This is the trouble we encountered last time, because I shared the draft even before it went to the committee. And then there are changes, and then I have to share it again. And I have a draft, I can share it, but it's going to the committee and it will likely change again.
When you say the committee, do you mean cabinet?
Yes, there's a cabinet subcommittee that considers and approves these things. So we put these things forward, and this is for approval for public consultation. This is to put forward what they think at this present time it should be for discussion purposes.
So Mr. Marshall, when will that draft? Oh, sorry. When will that draft be ready then, so that it can be shared with Ms. Mendez?
Yes, it's not sure.
And we circulated it, and we ourselves are waiting for the subcommittee to convene to deal with that. And as soon as we've settled that, we can share it. But I can share it even now, and that's what I did the last time. But we just go in loops.
Exactly. I think with respect, colleagues, that maybe the best approach would be to share it once that's gone through the cabinet subcommittee, and then agree that a meeting can be held within, what, 2 weeks of sharing it? How is that?
Yeah.
That sounds good.
Yeah.
That sounds agreeable, Your Honors, and that would be before August. That's the timeline.
Yes, we're committed to trying to get the policy out for public consultations by August. I think is the revised date, and we want to meet that.
Okay.
So then we would be before August?
Before August. Before the date in August. There will probably be a week or two in August. Was a date proposed?
I know.
Oh, they're saying by the end of August. So we'll have time.
Thanks, Chair.
Okay, well, I think that is at least some progress. I do think that really, although we understand all the emotions, as I said, there must be some trust between the parties, because without trust, you don't get anything done, and we need to get things done properly, but they need to be done. And we have been now in this process for 8 years. And as Justice Anderson said, we do not wish to see 10 years pass without.
Well, why don't we adopt that as an official objective, Chair?
No, it's not an
That we
objective.
want to, no, I mean, all of us on this call, the
Sure.
bench and the parties and so on, that we want to have this thing completed within 10 years.
Yes.
So that leaves us with only 2 years to go. I mean, why can't we accept that as an objective?
Yes, I think so.
I agree with that entirely. And when I look at the multiplicity of disputes that remain to be resolved, I recognize that it's not an easy task, which is why I'm suggesting we move forward with what we can and then let the rest catch up. I think we should move to drafting the legislation, and that's my own personal view of it, if we wish to see some result within the next 2 years.
Yeah.
Well, if we can get all of that done, it would be a major achievement. We have to realize that, of course. A small country like Belize getting something like that done. And once again, there will be no perfection. You cannot expect that. But at least if it's reasonably workable, then we would have gained a lot. And then as time goes by, we will see if further things can be done to make things even more perfect. But let's try to get everything done within 10 years. That means we have 2 years more as a maximum. But then everybody should be focused on that. Let me see. I think we went through the main issues.
We did, of course, discuss, as you said, Chair, the issue of the contract for the authority,
Yes.
but I'm not sure we resolved that. Maybe we should press Mr. Marsh to look a little bit more on why the authority is not in possession of a contract. When will that happen?
I must confess, I can't say why it hasn't. It's just a process going through, and the multiplicity of hands it passes through. From our perspective, the decision was made a long time ago that the authority is to be contracted and it's to be paid on a case-per-case basis. And that was the only issue that was raised to us at the time, that there was no point in these annual contracts when nothing was happening in the year. And that's why a decision was made to change it. As far as we're concerned, that decision is behind us. I don't know what's holding up implementation or execution of it. But I'll look into it.
That should be quite a simple contract in a way, because the basic instruments are there already. It is only not an annual thing, but on the basis of a case by case. And I suppose, as the authority did, with Professor Solorio, that case by case is a matter for payment, that you are paid by case, but that her contract, as it were, her powers are for a longer period than just for a case by case. Isn't that so?
Yes. Yes, it remains the same. And I remember, I think what happened was that hourly rate was agreed for the case per case payment. And so, as far as I'm concerned, all of that was settled. That's agreed.
Yes, but
in terms of the documentation, I'm not sure why a written document signed hasn't yet been produced.
Yes, Council, but I think you would confess that of all the people on this call, you are best positioned to provide a solution. And the fact of the matter is, the professor did make this point the last occasion that she was here with us. And it's a little embarrassing, frankly, that we are returned to the same position again. So could we not ask you to use your good offices to ensure that on the next occasion on which we meet, that this issue does not arise?
Yes, I will look after it personally.
Thank you.
I understand there were developments since the last time, so some progress was made, but I don't know why a document isn't signed.
Yes, thank you, sir.
Okay, but there will be a signed document next time we meet.
Yes,
At least you will work to get that done.
towards that. Yes, I
Yes.
advocate to try to
Excellent.
achieve that.
Okay. Yeah, is there anything you want to say to that, Professor Solorio? You about this contract? I suppose you.
Just wanted to say thank you, Your Excellencies, for your supervision and monitoring of the situation. I do think that your basically your intervention and your constant monitoring and your timeframes and benchmarks, I do think they're very important in this situation. And I think what has been happening with my contract is very emblematic, of the challenges that we have in this process. There has to be steps to build trust, between the parties, right? And I do echo everything that all of you have said today about the need for exchanges of information, the need for meetings, the need for formalized things. When you have more formality, you do accomplish more, right? And we were just talking about legislation. It's very important what was said by Judge Lee about meaningful participation. We even talk about effective participation. That is not just receiving written input, right? It's institutionalizing a space, where the Maya leaders, the appellants, can actually provide consistent input in all parts of the process, even though they're not legislators, of course, right? And I think what has been happening with my contract is very emblematic, of the challenges that we have in this process. Even though we're all working towards the same goal, I'm still in the process because I think it's a very important process. I think that what we're doing in Belize right now is something that a lot of countries are watching, right, around the world. There's a lot of expectations that this could be a positive experience, a good model for other countries. So I do think that this is a very important process to continue to be invested on. But from my end, it's been difficult, to manage the role vis-a-vis the government because of a lot of the issues that we have been discussing today. But I just wanted to thank you, Your Excellencies, for your constant supervision and monitoring, because I do think it helps, the process in general. And as you said, Justice Witt, I do think that we're all here for the same goal. And I find wonderful that we're thinking of a time frame, right? That we want to make sure that in 10 years this is resolved. I think that's a wonderful time frame to be able to resolve this kind of situation. So I just wanted to thank you all for your intervention in this process.
Thank you very much. Okay, I will pass word to Mr. Hughes, Mr. Marshallek, and then we will decide a date for our next compliance hearing. I do make the point that I think the position of the government is clear about facilitator and so forth. Of course, the court in a way plays that role of a facilitator. If things don't go the right way, we might have to intensify our supervision. I don't like to do that, but we need to get things done, and that I keep making that point. And I think grateful for Justice Anderson's point that let's make it the 10 years as a final deadline, and that means that we have another 2 years to go, and a lot has to be done in those 2 years, but it can be done. And if we keep our emotions a little far away, then a sound mind will prevail, and then we can get things done. Mr. Hughes is very short. If there is anything you want to say.
Not at all. Thank you very much, Your Honor, for the time that you've dedicated to this morning. I think we have made some progress.
Yes.
And I hope that with your, I don't want to say admonitions, but certainly with your observations, the parties will take all of that into account as we work towards a solution.
I'm sure you will play a role in achieving that. Ms. Mendes?
Nothing from me, Your Honors. I just wanted to clarify whether we will be getting a date from the government for the meeting shortly.
Yeah, so what will happen is, that this working group of cabinet or whatever needs to come together. They will approve a certain draft. As soon as that is done, Mr. Marshalik, that's how I understand it. As soon as you have an approved draft, you will circulate it. You will send it to the appellants, and there will be a meeting at least before the 1st of August. Is that correct?
Correct, except I'm not so sure about the 1st of August, before the end of August, sure.
I think the idea, sorry, Chair, I thought the idea was to give the appellants some period of time to review the report.
Yes, at least 2 weeks.
And I think we said about 2 weeks.
Yeah.
So it's hard to give a date now. It's within 2 weeks of the receipt by the applicants, by the appellants, of the report.
Yes.
Yeah.
Thanks.
Okay.
So we meet within 2 weeks of receipt of sharing the report.
Yeah, and before the 31st of August.
Correct.
That's how I understand. Thank you.
Yes.
And then I would want to the parties to notify the court about that date. So when you got I want the appellants to report to us that they got the updated draft, and I want parties to confirm the date that they will meet, so that we have that clear. So, yes. Then we need to have a date, and I will give Mr. Marshalik also word. But before I do that, we need a date for a next compliance hearing.
I assume that would be after the meeting.
Yes, somewhere, I suppose October, November.
Yes.
Well, any date in October would suit us. I don't think my calendar reaches that far this year.
The week of the 16th of October. Let's see.
Chair, I thought we would have preferred the earlier in October than the week of the 16th. I think we have commitments.
Yes.
Oh, yeah, that's absolutely true. Yes.
Yes.
I should not be able to forget that, actually.
No.
And I think we have a matter fixed for the 10th. The registry will be able to confirm. So we wouldn't want it there either.
Your Honors, is there a possibility to meet in the end of September?
September is in the break, so,
somewhere in the first week of October, but I'm not sure what the schedule is.
The first week in October is fine with us, early October.
It looks fine by my calendar as well.
Mine too, Chair.
Okay, so what day shall we take? Wednesday?
Mm-hmm.
Okay.
That is what date is that?
That's the 4th.
4th of October.
Yeah.
4th of October.
Is anyone on the call from the registry able to confirm if that is a free day for the court?
Is that available?
It is available, Judge.
Thank you so much.
It's available. Okay, 4th of October, 11 o'clock Trinidad time, 9 o'clock Belize time. We will have our compliance hearing. Parties will notify the court when the updated draft was received by the appellants from the respondent, and both parties will give us the date where they will meet to discuss this draft.
And I assume it might wish a compliance report as well, Chair?
And of course, there will be a compliance report at least 1 week. Maybe you want to have a date. In that case, it would be the 27th of September. Compliance report to be sent in not later than the 27th of September.
Obliged.
Okay, Mr. Marshall, anything else to say?
No, yeah. I would only echo what Mr. Hughes has said. We are committed to the process, and all of us, although it might not seem so at times, want to see a positive outcome.
Yes, and
there are a lot of moving parts, and none of us alone are in control of all of them. We have to convince bodies of people, and
yes.
There are diverse views and strong views on a lot of what in this documentation.
Yes, I think it's clear that the passions flare high every now and then, but as I said, we have to deal with this with a cool head. And okay, I just got a message that maybe it would be better if it's possible to file the compliance report not later than the 20th of September. Then we have more time to prepare ourselves. Is that a difficulty, Mr. Marshall? 20th of September?
The only thing that comes to mind is the 21st is, of course, our Independence Day. It's the day before the vacation.
Yeah, you can do it. You can do before it. You can do it before.
Probably better than after. So I think it's probably okay.
20th, Ms. Mendes?
That's agreeable, Your Honors. That's doable.
Okay, so that gives us some more time to prepare for the next hearing. Yeah, so as I said, let's really work together from all our different responsibilities. It's not a simple or feat at all. It's very complex. It can be done. It will be done. And we want to respect everybody's position in this as much as possible. We want to avoid further litigation, and I'm sure Mr. Marshall will advise the government that, inflexible positions may lead to that, and we don't want that. It only delays. If we can get this done, and we should get this done within 10 years, that means in another 2 years from now, it should be completely done. Then we have Belize has made a big move, and an impressive one, if I may say so, if we can get this done, and we can. So with that in mind, I will close these proceedings. I thank you very much. And Madam Registrar, could you close off?
Thank you, Justice Witt. Thank you, Justice Anderson. And thank you, Madam Justice Rajnath Lee. Thank you also to counsel. And finally, thank you to the court's staff. These proceedings are now adjourned.
Thank you.
Thank you.
Thank you.
Thank you.